per my undertaking, I made an undertaking to provide the defense with my heads by the 1st of September. But I wish to confirm that immediately when we adjourn on
State's address in opposing the application. It was delivered to my office. Thank you very much.
as it pleases.
As the court pleases.
There's an aspect that I canvassed with my learned friend just before we started. The court shall note that in the beginning of these proceedings, both the state and the defense agreed in terms of the applicable schedule. That was Schedule 5. And the matter has since proceeded in terms of that agreement. But the court shall note that only during his address, Mr. Dlamini placed an issue on the aspect of a schedule. And he gave reasons for that. I have since obtained a written confirmation in terms of Section 60, 11 capital letter A of the Criminal Procedure Act 51 of 1977, a copy of which was hand-delivered to Mr. Mopau, wherein the DPP, in terms of that section, confirmed that this is indeed Schedule 5. I wish to hand this over to the court, and if no objection from the defense.
Mr. Motlahu?
As it pleases the court, Your Worship, I confirm that I received this notice from the Director of Public Prosecutions, Free State, in as far as the schedule of this offense is concerned. Your Worship, receipt of this or acknowledgement of delivery of this notice should not in any way, shape or form be misconstrued to be a concession on the part of the defense in as far as the argument is concerned relating to the schedule. Your Worship, I would not take this further and I would address it sufficiently when I have the opportunity to do so at a later stage as a court pleases.
Thank you. The written confirmation in terms of Section 60, subsection 11 capital A, subsection A of the Criminal Procedure Act is received, and it is marked as Exhibit
In terms of my records, the last exhibit was H. Is the written submission by the applicant. No, it was the affidavit. H. Then there was-
Exhibit J was also received an exhibit. Let me just go back to the exhibit itself just to make
Yes.
sure.
I think the written address by my learned friend was Exhibit I.
And then J.
J.
Right, let's mark this exhibit K.
As a please the court.
As it is the continuation.
Yes,
Can I just indicate what is written on this confirmation? It was issued by Advocate Navila Sumaro, the Director of Public Prosecutions,
that's correct.
indicating and confirming that the applicant before court, Ms. Magudumane and 11 others, will be arraigned on inter alia 4 counts of contravening Section 3 of the Corruption Act, and that for the purposes of bail proceedings, corruption falls under Schedule 5 of the Criminal Procedure Act as it involves more than 500,000, or it involves amounts of more than 100,000 if it's alleged that the offence was committed by a person or a group of persons or syndicate acting in the execution of furtherance of common purpose or conspiracy. So that this is what is contained
As a
in
president.
a summary of what is contained in this document. I haven't read out the full document, just for your information.
Yes, can I, with the permission of the court, can I ask that we swapped seats with Mr. Mutlou? He indicated that he would need a podium, and we went around the whole building to try and get him a podium. Unfortunately, they are all fastened like this, they can't move. So for his address, can I allow him then to address you from here?
Yes, you
As
may.
a president.
Thank you, Ms. Mr. Mutahung, I'm sitting slightly with my back towards you, and it's not out of disrespect or anything. I'm just trying to work on my laptop, and I've got some of these microphones in my space.
That's
So please
understandable.
excuse me for doing
That's understandable, Your Worship. I must also indicate that it feels a bit awkward that I'm standing on the other side of the fence. I hope this would not really go down to even impact on my address, but I still appear on behalf of the applicant, Your Worship.
Thank you.
Your Worship, I think what one is required to do in this bail application, take into account that this is a continuation from the address that was presented by Advocate Dlamini on the 30th of August 2023. In avoidance of regurgitation of some of the aspects which were eloquently articulated and dealt with by my learned colleague, one would just to have a structure and framework of my address, point out salient issues emanating from this address of my learned colleague. Your Worship, you would note that our address commenced with the preliminary issues. Now, I intend to address the court under the following topics. My learned colleague dealt with preliminary issues pertaining to the schedule. I'm not going to delve deeper into those issues, except to say, in the light of the notice that has been dispatched by the DPP's office, I'm inclined to provide a brief response thereto. Your Worship, the next topic that my learned colleague dealt with related to the charges preferred against the applicant. And he then further dealt with the topic around the state's case. And he spent quite some time dealing with the issues emanating from the state's case. From time to time, Your Worship, I would piggyback on some of the issues emanating therefrom. The topic that I will address this court on will be the applicant's case, and thereafter I will address the court on the absence of the provisions of section 60 subsection 4 A to E. So in essence, I'll deal with bail legislation in respect of this matter. Your Worship, I will then move to deal with the applicable law, inclusive of case law, in demonstrating to this honorable court that the interest of justice exists in this matter, and that the state, in its opposition of the applicant being released on bail, did not establish any of those factors as delineated in the in section 64 A to E. Your Worship, the background details in this matter and the germane facts in this matter are quite straightforward. The applicant approached this honorable court with an application for her release on bail. She deposed an affidavit by demonstrating to this court various factors that would show that the interest of justice permits the release of the applicant on bail. I would like to zoom into some of these factors emanating from the applicant's affidavit. I will demonstrate to this court that these factors, until now, and some of those, have not been sufficiently, if at all, being addressed nor undermined by the state in opposition of bail. Your Worship, the affidavit, among others, touched on personal circumstances of the applicant. Now, this point is quite crucial when determining the suitability of the applicant to be admitted to bail. All the factors in her affidavit in respect of personal circumstances remain but undisputed. Now, it's tried law that where evidence remain undisputed, that evidence automatically should be accepted by this honorable court. My submissions are that the evidence in as far as personal circumstances are concerned. It's not even riddled with any improbabilities. It's not far-fetched. Succinct to the point that the applicant has strong family ties within the area where she resides, including strong family and occupational ties in the Republic of South Africa. Now, one will pause and check the affidavit by the state in opposition of bail and try and locate any aspect from the state's opposing affidavit which negates this very essential element of the applicant's case. It goes without saying, Your Worship, that there is nowhere in the opposing affidavit where this issue is being attacked by the state. Your Worship, we will then move to the travel documents. It's also a point that is common cause, that the applicant's travel documents have been confiscated. Her passport, according to her evidence, was confiscated. Now, what is the relevance and essence of this assertion? The relevance, Your Worship, I submit with respect that it touches on the very vein of section 60 subsection 4b, that should the applicant be released on bail, is there a likelihood? And by the way, the inquiry there is not just merely a likelihood of the applicant for bail evading trial, but the likelihood that the applicant will attempt. And I'm saying this with emphasis. It is therefore incumbent on the state to produce evidence and not merely speculate, produce tangible evidence to the effect that there is a likelihood that the applicant will attempt to evade her trial. In this instance, Your Worship, the applicant made it quite clear, played open cards to this honorable court, that I have travel documents, but it has been seized. But it does not even end there. My learned colleague eloquently put forward a point that is crucial for the determination of this aspect, to say the state in its own opposing affidavit indicated how the applicant has been traveling in and outside the Republic of South Africa, coming back with no issues whatsoever. So even in the most extreme of cases, should it be found that the accused had a passport, could have been the accused would readily surrender such passport. But in this instance, the accused's passport the applicant's passport is confiscated. Now the question here, crisp question around this issue, is whether or not the accused has any other business to do or deal with outside the Republic of South Africa. And to this end, the applicant has not adduced such evidence, neither did the state in its opposition of bail adduce evidence to the effect that the applicant has some interest outside the borders of the Republic of South Africa. Your Worship, the applicant's family background has been placed on record through the affidavit. Even then, this evidence is not disputed at all. In actual fact, to lower the bar a bit, it's not challenged. The state has simply accepted the background details of the applicants with regards to her family being living in Port Edward, having 3 siblings. All of those facts were not just facts that are placed on record as evidence without any basis. The basis of us placing these facts in the affidavit simply to demonstrate to this honorable court that the applicant has strong family ties within the Republic of South Africa. The issue of the assets also features in the affidavit of the applicant. She indicated there the type of assets that she has. This augments the applicant's case to a large extent, mindful of the fact that the criteria can never be that anyone without assets might find him or herself on the back foot. But the reason why we mention the assets, particularly movable assets, by the way, movable assets to the value of R1 million, that is quite a substantial amount. Now, this aspect touches sharply the vein of Section 60, subsection 4B, in respect of whether or not that risk, that likelihood of an attempt to evade trial is completely diffused, because the inquiry should be, can the applicant afford to lose these assets? I will pause here with regards to this, because it's a point that one has to deal with it holistically, zooming into the argument by the state, to the effect that the applicant has everything to lose, particularly on the strength of the state's case. The state is saying Section 64, pardon me, Your Worship, Section 64B finds applicability here on the basis of the state's case being strong. By the way, Your Worship, this appears from the state's opposition of bail to be the only ground that the state presents to this court, the ground that the state is of the view is demonstrable of the likelihood existing. Now, at a later stage, I'm going to illustrate how some of the concerns could be cured, and this will be cured in terms of our own legislative processes. Legislation is mindful of some of the concerns that would arise in respect of admitting an applicant to be released on bail against the backdrop of a fear or concern that the applicant may attempt to evade his or her trial. My submissions are, Your Worship, that when we zoom into section 64B, that we need not only look at this factor of the state in isolation, that my learned colleague pointed out assortment of anomalies emanating from the state's case. If the state's case, or if the state's submissions is to the effect that they have a strong case, my learned colleague has dealt the state's case a blow by listing a myriad of factors pointing out the shortcomings in the state's case. I would sufficiently, as I deal with case law and legislative provisions, I'll sufficiently deal with this aspect from the state's case. Your Worship, the applicant in her affidavit indicated that she does not have previous convictions, neither does she have any pending cases. This is quite crucial. This is quite crucial because this aspect, Your Worship, largely touches on the provisions of section 60, subsection 4A, the propensity to commit further offenses if admitted to bail, and that's a likelihood, by the way. Your Worship, we need not delabor on this point any further. We need not overburden this court in respect of this aspect. We will take it that by law, this is a legal position and there is no two ways about it. The assertion with regards to registered cases has been dealt with by my learned colleague. But I must indicate that the bearing thereof, if there is any, of some other cases being investigated, that would not have any bearing whatsoever in respect of this application. Before this court, applicant has no previous convictions. Before this honorable court, the applicant has no pending cases. That's the end of the debate. You can't take it any further. Any desperate measure of trying to take those issues out of so-called registered cases is but unhelpful to us. Your Worship, there is also a mention of civil case. At what point do we even argue pending civil case? At what point do we even argue judgment of a civil court having a bearing on proceedings of this nature? But I will take it further, that the applicant has pursued a civil route to challenge the lawfulness and unlawfulness or otherwise of her apprehension in Tanzania. That's common cause fact. It's also common cause that the entright law, by the way, that the results, the cost follows the result. But the state comes to this court, also mentions the approximate amount of cost incurred this far. must indicate that I find no relevance of that, particularly when we know, in terms of the civil processes, that a bill will be drafted, it will be presented to the taxation master for taxation purposes, and all those processes must be observed. But the relevance of that, the ones that I've pointed out, to try and analyze the rationale behind mentioning those. I respectfully submit, Your Worship, that until now, I have demonstrated to you that the evidence as presented by the applicant remains unchallenged. Now, Your Worship, there is a paragraph in our affidavit which can be located in page 8 thereof. And this paragraph deals with circumstances around my departure from South Africa. To this end, what we have here is the applicant for bail delineating to you her departure from South Africa. And the point that she is driving home is that I did not depart from this country voluntarily. And, Your Worship, she is saying, I am mindful of my right to remain silent. By the way, it's a crucial right in proceedings of this nature, including in criminal proceedings. It's a crucial right, the right of the applicant to remain silent. But she is saying, I'm taking this court into confidence to the extent that I just have to illustrate to this court the circumstances flowing from my departure from South Africa. Brief as it could be, but it does not negate the fact that she departed from South Africa involuntarily so. Now, anything to the contrary is but casting aspersions. Anything to the contrary is but trying to zoom into the rationality of the, or probability rather, of this version. Now, the state, in trying to rebut this, and I'm saying in trying to rebut this because I'm saying so deliberately, because it doesn't come out clear whether the state really rebuts this version and puts another version. Because then it will have come to this court succinctly that, wait a minute, you allege to have involuntarily exited the borders of South Africa, but we have on good authority that this and that happened. But what the state then attempts to do is to say, look, how could it be possible that you could involuntarily depart, and whilst there you crossed other borders or you came across other people Could you have issued SOS to the effect that I have a problem here? They take it further to say, couldn't you, by the way, there is a tracker which confirmed you being in KwaZulu-Natal with Thabo Bester shortly after the escape. Still not sure. Perhaps the state they might have a sophisticated technology in terms of that tracker, but it didn't come out clear or come out at all from their evidence that the tracker showed the applicant's face, placed the applicant on the scene. It's merely about what I will term circumstantial. If I have to go there, circumstantial, that this is a vehicle belonging to the applicant. The only inference, I wouldn't say reasonable, an inference that can be drawn is that it was driven by the applicant. They furthermore downloaded some images. My learned colleague dealt with that. Obviously, the provisions of the Electronic Communications and Transaction Act, ACTA, are quite very clear in terms of reliance on video material, reliance on images that are to be used, and the procedure that has to be followed in order to have evidentiary weight. Not only that, Your Worship, but to also have such evidence admissible in court as evidence. What we have is pictures of people sitting, looking at each other. Is two pictures. The reason the state is resorting to that strategy is simply to undermine the allegation that I involuntarily left the country. Your Worship, the state's approach there is problematic. Problematic in that this is a space and zone of experts, by the way, in as far as the reaction of the applicant is concerned. Surely we don't have any form of expertise to even interpret someone's reaction and to be conclusive in terms of how a person could have reacted in a particular circumstances. Those factors are unknown at this moment. Hence, the defense, we actually find it very problematic that you can create those insinuations that according to the investigating officer, he signed out from his evidence by indicating the distance between South Africa and Tanzania. He leaves us second guessing the purpose. Could it be that they want to show this court the distance traveled? They take it further to say and draw some comparison that the